In this video, I'm going to walk you through exactly how to sue your Florida Homeowners Association. And by the end of this video, you'll know the legal steps you need to take, the mistakes that get most cases thrown out, and whether your situation even calls for a lawsuit in the first place. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years helping homeowners fight back against HOA boards that abuse their power. And let me tell you, this is one of the fastest growing areas of legal conflict in the state right now. And here's why this matters to you. If you own property in a Florida HOA community, you've already signed away certain rights. But that doesn't mean your HOA can do whatever it wants. Florida law gives you real protections, and most homeowners just don't know about them. That changes today. Before you file anything, you need to figure out one thing. Do you actually have a valid legal claim? Not every frustration with your HOA is a lawsuit. Let me save you time and money right now. There are specific situations where Florida law is on your side. If your HOA selectively enforces its rules against you, but ignores the same violations from your neighbors, that's called selective enforcement. Courts in Florida take this very seriously. It's one of the strongest claims a homeowner can bring. Now, if your HOA board is mismanaging funds, refusing to provide financial records, or spending your assessment dollars on things that don't benefit the community, you may have a claim for breach of fiduciary duty. Every board member in Florida has a legal obligation to act in the best interest of the homeowners, not themselves, not their friends on the board, you. Another major area is failure to maintain common areas. Your HOA collects fees for a reason. If the community is falling apart while the board sits on its hands, that's a breach of the governing documents. And those documents, your declaration of covenants, your bylaws, your articles of incorporation, are legally binding contracts under Florida law. Then there's the issue of access to records. Under Florida Statute 720, which governs homeowners associations in the state, you have the right to inspect the official records of your HOA. If the board stonewalls you or charges outrageous fees to see basic financial documents, they're violating state law, period. So ask yourself, is my HOA selectively enforcing rules, mishandling money, neglecting the property, or blocking my access to records? If the answer to any of those is yes, keep watching. You may have a real case. Now here's where most people mess up. They get angry, hire a lawyer, and rush to the courthouse. That almost never works with HOA disputes in Florida. The state has mandatory pre-suit requirements you have to follow. Skip them, and a judge will toss out your case before it even starts. The first step is sending a formal demand letter. This isn't a nasty email to your HOA president. This is a written legal notice that identifies the specific violation, cites the relevant section of your governing documents or Florida statute, and gives the HOA a reasonable deadline to fix the problem. Your attorney should draft this. It sets the tone for everything that follows. After that demand letter, Florida law often requires you to go through either mediation or arbitration before you can file a lawsuit. This depends on the nature of your dispute. For many HOA conflicts, things like covenant enforcement, use of common areas, or rule disputes, you'll need to go through the Florida Department of Business and Professional Regulations arbitration program first. This is not optional. It's required under Florida Statute 720.311. Mediation is different. It's a voluntary negotiation process with a neutral third party. Some HOA governing documents actually require mediation before any legal action. Check your bylaws. If mediation is required and you skip it, the court will send you right back. I know this feels slow, but following these pre-suit steps actually strengthens your position. It shows the court that you acted in good faith. It shows that you tried to resolve this without litigation. Judges notice that, and it puts pressure on the HOA to settle before things get expensive for them. Quick thing before we keep going. If this information is helping you understand your rights as a Florida homeowner, do me a favor and hit that like button right now. It helps this video reach other homeowners who are dealing with the same issue. And if you want more content like this on Florida real estate law and property disputes, subscribe to this channel so you don't miss the next one. All right, let's get back to it. So you've sent your demand letter, you've gone through mediation or arbitration, and the HOA still won't budge. Now it's time to file. Your attorney will prepare a civil complaint and file it in the circuit court of the county where your property is located. In South Florida, that's usually Miami-Dade, Broward, or Palm Beach County. The complaint needs to lay out your claims with specificity. Vague allegations won't survive a motion to dismiss. The most common legal theories in Florida HOA lawsuits are breach of contract, breach of fiduciary duty, and violations of Florida Statute 720. Some cases also involve fraud, negligence, or even federal fair housing claims if the HOA's actions are discriminatory. And here's something most owners don't realize. In many Florida HOA disputes, the prevailing party is entitled to recover attorney's fees. That means if you win, the HOA may have to pay your legal cost. This is huge. It's written right into most governing documents and reinforced by Florida statute. It also means the HOA has a financial incentive to settle before trial. Their own attorney will advise them of that risk. Now, let me be real with you. Lawsuits are not cheap or fast. Even a straightforward HOA case in Florida can take 12 to 18 months or even longer. Complex cases stretch much longer. But if your HOA is violating your rights, sometimes litigation is the only language that they understand. And one more thing on filing. If your dispute involves a smaller amount, say under $8,000, you may be able to file in small claims court. That's faster and less expensive. You don't always need an attorney in small claims, but I strongly recommend at least consulting with one before you go that route. There are other procedural traps that can sink your case if you're not careful. Once the lawsuit is filed, the HOA has 20 days to respond. Then you enter what's called the discovery phase. This is where both sides exchange documents, answer written questions under oath, and take depositions. For HOA cases, discovery is where you often find the smoking gun. Now, maybe the board's meeting minutes reveal they targeted you specifically. Maybe the financial records show the treasurer was funneling assessment fees into a personal account. Maybe the emails between board members show they acted with malice. Discovery brings all of that into light. And after discovery, most cases go through another round of mediation. This is court-ordered mediation, and it's often the point where settlements happen. The HOA's insurance carrier gets involved. The board's attorney gives them a realistic assessment of their exposure, and suddenly the board president, who refused to talk to you, is very interested in making a deal. If mediation fails, the case goes to trial. In Florida Circuit Court, you can request a jury trial for most HOA disputes. Juries tend to be sympathetic to individual homeowners, especially when the evidence shows a board acting like a small town dictatorship. Now, here's my honest advice. Most HOA cases settle. Trials are risky for both sides. A good Florida HOA attorney will push for the strongest possible settlement while keeping the trial option credible. The balance is where the real leverage lies. Let me leave you with a few things that protect your position, whether you're headed to court or just starting to have problems with your HOA. Document everything, every letter, every email, every interaction with the board. Take photos with timestamps. Save voicemails. If something happens at a board meeting, write it down that same night. Memories fade, records don't. Know your governing documents inside and out. Your declaration of covenants, conditions, and restrictions, your CC&Rs, is the rule book. If the board is violating it, you need to be able to point to the exact section. The same goes for the bylaws and any amendments. Stay current on your assessments. Even if you're in a dispute with the board, pay your HOA fees. Falling behind on assessments gives the HOA the right to lien your property under Florida law. And that weakens your legal position and gives the board ammunition against you. And finally, consult with an attorney early. Don't wait until you're in a full-blown war with your HOA. A 30-minute consultation with a Florida HOA attorney can tell you if you have a case, what your options are, and what your next move should be. That early guidance can save you thousands of dollars and months of stress. If you found this video helpful, make sure to hit that like button and subscribe to my channel. I put out new content regularly on Florida property law, HOA disputes, real estate litigation, and business law. The more you know about your rights, the harder it is for anyone to take advantage of you. Share this video with a neighbor or friends. who are dealing with their HOA right now. It may be exactly what they need to hear. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.